Is India serious about international law in your experience?
There are certain laudable initiatives that India has taken in the past and also in the last few years.
Hello and welcome to Justify. Since the start of the Cold War, India has been a champion of non alignment. NAM sowed its seeds in the collective response of recently decolonized nations towards an increasingly bipolar world order. As the world becomes bipolar again, the question before us is a simple one. Is India again a balancing power, or is India becoming a leading power, as it somehow sometimes seems to suggest on the world stage? There's no doubt that in the 21st century, India plays a very pivotal position in the world order. It promotes South South as well as South North cooperation. It's deepened trade and diplomatic ties with the global South and the global North alike, ranging from Nigeria and Angola to the US, UK, and EU. For multilateral negotiations, it has emerged as a crucial bridge with its recent presidency of the G20 and its active role in climate governance through the COP as well as the UNFCCC. On the other hand, India's role as a consistent global leader may be hampered by weak institutions, inequality, and an unstable neighborhood. The recent war with Pakistan over a dastardly terror attack in Pahalgam, followed by the full scale military operation Sindoor, shows how precarious India's geopolitical situation is. So the question is, will India transform into a pole in the global order, or will it be continue to be a swing state, its actions determined by its immediate neighborhood? In this context, the elephant in the room is international law. India has long been a believer in international law. It's long been an active player on the global stage. But is it now time that India takes international law more seriously, not just as a follower and a participant, but a leader and a norm maker? To discuss India's role as a potential norm maker in international law, I'm delighted to welcome my guest today, Professor Prabhash Ranjan. Welcome to the show, Prabhash. So before we go any further, I'll introduce Prabhash to my guests. Many of my guests are law students, so will know Prabhash very well. Prabhash Ranjan is an eminent international law scholar focusing on international investment and trade law. He's currently the Vice Dean of Research and the Director of the Center for International Investment and Trade Law at the Jindal Global Law School. As an external consultant, he has advised the Center for WTO Studies, UNDP, IIFT, and UNCTAD. He also took part in the drafting of the report of the Law Commission of India on the 2015 Draft Model BIT. With extensive publications that have been cited over 600 times, Prabhash has been a leading policy voice advocating for more serious thinking around international law in India. So, Prabhash, I'll jump right in. Is India serious about international law in your experience?
Orgo, the answer is yes and no. The short answer is yes and no. There are certain laudable initiatives that India has taken in the past and also in the last few years. Just to give some quick examples, so since India has been one of the victims of terrorism, in 1996, India played a key role in proposing what is known as the Comprehensive Convention on International Terrorism. But unfortunately, this treaty has still not come into existence. But this is a major initiative that India took in reshaping international non-terrorism. Likewise, few years back, India took the initiative to create what is known as the International Solar Alliance. So that again is a very bold, audacious attempt in reshaping international environmental law. But apart from these few examples, one would struggle, at least in the recent years, in the last few decades, one would struggle to find examples or instances where India has actually led or played a pivotal role in shaping international law. In fact, if you were to look at some of the specific, state conduct where India could have used international law more effectively, unfortunately, it hasn't. And that actually shows that while India's stature as an emerging power has certainly become stronger in the last decade or so, of international law and shaping of international law hasn't quite kept pace with that growing stature. So just to give you a recent example, let's take the India-Pakistan recent conflict, Operation Sindoor. So, when India offered its justification for hitting the nine terrorist infrastructure in Pakistan, uh, did not very clearly articulate the legal principle which it had followed. So, for example, India partly said that we are doing this because the actions of the terrorists are attributable to the state of Pakistan. It then also said that we are doing this because Pakistan is unable or unwilling to take action against these terror groups. But despite doing all this, India did not invoke right to self-defense under Article 51 of the UN Charter. The Foreign Secretary statement said that India is using its right to respond. Now, right to respond is not really a vocabulary that is known to international law. In international law, you have right to self-defense, and I think it would have been better if India had categorically invoked Article 51 of the UN Charter. Now, there could be various reasons why India did not do that. I don't know what the reasons were, but maybe one reason could be that you can invoke right to self-defense only when you are able to clearly demonstrate that the action is attributable to the Pakistani state, which India claims that it is. It has the evidence. Now, if it has the evidence, then it should have gone the full distance and said that we are invoking right to self-defense. So this is just one example to demonstrate that how international law is not being invoked as effectively as possible. Likewise, just to give one more example related to this, when Pakistan invoked right to self-defense, to justify its strikes on 8th of May, India should have countered that. India should have said that you are the aggressor, and therefore you cannot invoke right to self-defense, which India didn't do. So these are just some sort of recent examples which
No, I think
demonstrate
these are
that.
great points, and I
Yeah.
want to actually dive into this because you raised the Pahalgam issue, which is really the reason as to why we are having this set of podcasts in the first place, to look at what more leverage we can get out of international law in a situation like this. Leverage not just as a nation, but leverage essentially as a nation following the rule of law. So I want to drill down on this question in relation to self defense. Now, self defense jurisprudentially as a concept is well understood both in domestic criminal law as well as in international law. So, I want to ask you specifically that do you think that there is a case for India to have made that this is self defense? And if so, what would it need to demonstrate? We are not on the rightness and wrongness of the actions because of the fact that there must be some good reasons why the foreign secretary said what he did. So let us assume that they understood what self defense is. But for our listeners, what are the legal ingredients for a successful self defense claim in international law?
Now, most scholars are of the view that that armed attack has to be attributed to the state if there is military action taken by, say, say India against Pakistan. It has to be attributed to the state of Pakistan. Now, if you look at the statement that India has made on this occasion and also India's utterances in the past, India has always made this claim that action of these non-state actors, the terror groups operating from Pakistan, are attributable to the state of Pakistan for a host of reasons. And then there is, the ICJ interpretation in the US, Nicaragua, and other cases that there has to be effective control over these non-state actors. Only then action can be attributed to that state. So this will then boil down to what kind of evidence India has and what kind of evidence India can demonstrate to show that there is effective control. In my opinion, there is effective control because these are not just some terrorists which just Pakistan is supporting. They're actually very much part of the Pakistani foreign policy and Pakistani state instrumentality. So this is one option, one route that India could have explored, which is the traditional route. The problem here, the legal problem here is proving that this is attributable to
Right.
the state of Pakistan. That has a higher threshold. The other option, which increasingly countries like US, UK, Australia, Canada, North America, North American countries, Israel, etc., have followed, is what is known as the unable or the unwilling test.
So, Prabhash, I want to drill down a little bit deeper into this test of unwilling and unable, which seems to be emerging as a second test to trigger self-defense claims. So, could you tell us a little bit more about that?
Yeah, so the unable or the unwilling test, Orgo, basically allows countries to expand the scope of Article 51. It basically says that if there's a non-state actor in country A which is perpetuating attacks against country B, and if the state of the state in A is not able to act against this non-state actor or is not willing to act against this non-state actor, then country B against whom these attacks have been carried out can take military action against these non-state actors. Now, this arguably can be justified under Article 51 of the UN Charter, right to self-defense. The advantage with this approach is that you do not have to show state attribution. So you don't have that high threshold to be crossed. That's an advantage of this. But the disadvantage of this is that it expands the scope of Article 51 a little bit. And maybe countries like India or other countries do not want that to happen, and therefore they are not fully prepared to adopt this test. That could be one justification why India did not fully adopt this test.
And a subsidiary question that arises is that what is the extent of action permissible under a self-defense claim? Because we've been witnessing in the Gaza conflict, Israel, which has claimed the right to self-defense, now most recently having bombed a house in Khan Yunis, where nine children, tragically, of a pediatric doctor have been killed while she was on duty in a children's hospital. So even if India were to take a claim that this is self-defense, whether on the first test or the second test, what is the extent of action that is permissible in self-defense?
So there have to be two very important things that have to be satisfied. First is necessity, and second is proportionality. So you have to demonstrate that there was a necessity for you to undertake the attack, and most importantly, your military action or retaliatory action has to be proportionate. Israel is a bad example in this because Israel's actions are hugely disproportionate in terms of hitting civilian infrastructure, killing civilians, killing children. If you look at India's military strikes, not just the recent ones, even if you go back to Balakot strikes or the surgical strikes earlier, I think India's strikes were proportionate and necessary. And I think the foreign secretary repeatedly, not just in the original statement, but repeatedly made this point that our
Absolutely.
strikes have been proportionate and necessary. So proportionality and necessity are two very important
Absolutely.
ingredients.
So that actually gave me the sense. The number of times that I heard the foreign secretary use the word necessary and proportionate, it seemed that there were some international lawyers advising on that, because it seemed very much language that was that was language of international law. So I wanted to understand from you, given the fact that you've seen the system both from the inside as well as the outside, what would it take for India to become a norm maker in international law? Clearly, we are somewhere there. We speak the language of international law, we understand it, we sometimes use it strategically, sometimes we don't. But what would it take for India to take that next step to become a leader in international law as a precursor to being a pole in the new global order?
So, Orgo, first of all, I think the occasions on which India has used international law effectively are far few than the occasions when India hasn't used the language of international law effectively. I mean, that's the first point. Now, what India needs to do, I think there are a host of things that India will have to do. It has to first start by strengthening state capacity, that is the capacity within the government. So if we look at if we look at Indian bureaucracy or India's overall government structure, within the Ministry of External Affairs, you have the Legal and Treaties Division, which is supposed to do the heavy lifting when it comes to international law. Now, there's a report of the Parliamentary Committee on External Affairs of 2021, which says that this division currently has only 13 officers, whereas its sanction strength is 23. Now, I don't know if in the last few years they have recruited more people and they are operating at their sanction strength, but they have always historically operated much below their sanction strength. So the international law professionals who need to be in the system advising the government on these matters, that needs to be strengthened. I mean, that's the first thing. The second thing is even in the legal and treaties division, how do you recruit international lawyers? What process do you follow is also something that needs to be discussed. I mean, it would be interesting for listeners to know that these people who work in the legal and treaties division they do not belong to the Indian Foreign Service, right? They also don't belong to what is the Indian legal service, whose people work in the law ministry, for example. They have their own cadre. Now, there they recruit people who have 5 years of experience after LLM. So, as a result, a lot of people and a lot of young students or young lawyers who want to make a career in international law, they perhaps do not want to wait for 5 years and then they go ahead and do other things. So, the people that they get, may not perhaps be the best talent. So that's also a structural issue that needs to be dealt with. The third thing that I think within the state capacity, within the government, is the involvement of too many ministries when it comes to dealing with international law. So just to give you an example, I was a consultant with the Commerce Ministry on WTO negotiations, on dispute settlement negotiations. And it was very interesting for me to note that in that entire process, there was no one from the legal and treaties division who was involved in advising the government or telling the government on WTO matters. Whereas if you look at the official rules of business, it very categorically says that the L&T division has to be involved in all treaty negotiations, irrespective of the subject of international law. So lack of coordination between different ministries also plays a very important role. So somehow international law has not been mainstreamed into our foreign policy. Of course, the generalist nature of diplomats is also partly responsible. But that would be true for many other countries as well. It's just that the other countries, especially the developed countries, have their very strong international law cadre, which is missing when it comes to the Indian government and the MEA.
So hold that thought because we'll come back to it before the end of the podcast. I do want to pick your brains about how we can build state capacity and particularly look at younger lawyers working with the Legal and Treaties Division or working for India in whichever capacity at these forums. But before we get to that, let's get to your core area of work, which is international trade. Now, at this point of time, we seem to be in the midst of a real tumult as far as the global world order is concerned when it comes to international trade, particularly because of the policies of the Trump administration. You have argued in an Indian Express column that India should strengthen trade multilateralism. If India is to do that, in my view, what should it, in your view, what should its top priorities be in the WTO as it finds itself today? And two, how do you see this call for strengthening trade multilateralism sitting side by side with this spate of FTAs slash BTAs that we seem to be signing, or at least imminently signing, or wanting to sign with several countries in the West? So, do you see the world order as one of significantly strengthened multilateralism or seen as stronger bilateral relations?
Okay, so to answer your first question on this, Orgo, I think it has been India's traditional position throughout that India believes and champions multilateralism, and this is true for international trade as well. There are many reasons for this because multilateral system is supposed to be a better guarantor for developing countries like India in comparison to bilateral negotiations. So we have WTO as a multilateral organization which has its own structures, systems, processes in place, which ensures a more effective participation of developing countries. There are special and differential treatment provisions which have been institutionalized within the WTO system. So those things work to the advantage of developing countries like India. Now, so this is the reason why India historically has always championed for stronger trade multilateralism. Now, we know that trade multilateralism today is facing a crisis, and many people attribute this to President Trump, but in many ways it goes back to the time of President Obama. Now, what India needs to do is that India has to continue championing multilateralism, trade multilateralism, which India has stopped doing in the last, if I may say, last year or so. Especially when President Trump launched this full onslaught, full frontal assault on multilateralism through his reciprocal tariffs, etc. Strangely, India kept quiet. India did not call out the US for its blatantly illegal actions of imposing reciprocal tariffs and of doing things which trade multilateralism or WTO law does not recognize. Listeners would be interested to know that there was a statement issued at the WTO last month in support of multilateralism that was signed by 40 countries, including many developing countries. And strangely, India was not a signatory to that statement. I mentioned this in one of my pieces that I wrote for the Hindu. So India traditionally has been a champion of trade multilateralism, but of late it's not showing the same interest. So what India needs to do is India needs to champion it, reiterate its importance at every single forum. Second and specific, I can talk about the dispute settlement mechanism, which we all know is I mean, WTO's dispute settlement mechanism is like this crown jewel in international dispute settlement. Its appellate body has not been in existence for last 6-7 years, largely because US has been blocking the appointment of appellate body members. Now, European Union came up with this alternative system, what is known as the multi-party interim arbitration arrangement, which resurrects the appellate function. Now, I am of the view that India should actually be supporting this, but India hasn't supported this because if India wants a two-tier dispute settlement mechanism at the WTO, then supporting the European Union on this proposal can be a good way forward in order to tell the US that we can safeguard the system even when you are not on board with us. So these are some things that India needs to do to
But
answer your.
what are the potential
Sorry.
reasons that India is not supporting the EU proposal?
There are mix of reasons, Orgo. The immediate reason is that India had lost quite a few cases at the WTO, and therefore it suited India to appeal into the void. Since the appellate body is not there, you just file an appeal; it goes into the void because there are no appellate body members to hear that. If you become a member of the MPIA, the Multi-Party Interim Arbitration Agreement, then those cases would be heard, and you might then be required to enforce those, follow those rulings which the appellate body might give. So it was this immediate short-term benefit that India saw. Also, India believes that supporting the EU proposal might lead to a situation where the appellate body may not come back to life ever because US would then say that, okay, you're already supporting the alternative arrangement. So then where is the need to get the appellate body again? So this could also be a reason why India is hesitant to support this.
So
Now,
these are
yeah,
not principled considerations. These are some kinds of short-term considerations on the basis of will we win this case, will we not win this case. As a
yes.
domestic lawyer, I see this quite often in how judges are appointed and how government reacts to certain decisions. It's very short term in terms of do I like this judgment or not, and so I think this is okay. But we are not looking at it the bigger picture. And so, Prabhash, if it is that, then the question is that is India not looking at the bigger picture because it's still somewhere, despite the rhetoric that we are becoming a leading power, it's still somewhere in the forum of international law globally, sees itself as a follower. It's either the US approach or the EU approach. We are not thinking in terms of what might be a good approach that works for the world and is also pragmatically good for us. So, do you think somewhere it's about a lack of imagination or vision of what it means to be a leader in international law?
Yeah, I'll say it's largely guided by short-term considerations, but I'll not say it's completely guided by that. There are some principled concerns as well. As I mentioned, that that if we support the proposal of EU, then we give up, in a way, we give up on getting the appellate body back, because that is the ultimate objective. But yeah, largely it's short-term considerations. On the larger point that you make, yes, I agree with you. I mean, India's approach still is more a knee-jerk kind of, how do we safeguard our interest in the immediate run till the next WTO ministerial, for example, without actually proposing a long-term vision, a long-term, a new trade architecture, if I may say, for the globe, which is also beneficial for India. So there is a lack of strategic thinking, notwithstanding the rhetoric of, we have arrived and stuff like
If I
that.
were to play devil's advocate, I would perhaps, not as a trade lawyer, but someone who's just closely observing India on the global stage, perhaps argue that what India is trying to do with its bilateral trade agreements, as in with the UK, we've just signed one, talking to the EU, saying that there'll be one with the US by the end of the year, uh, is that we are moving from away from this stated position that we had till a few years back, that is of strengthened multilateralism, to some kind of pragmatic bilateralism. So, do you think that that is a product of long-term thinking, or would you say that it's too early to say that?
I think it's too early to say that, but let's put this in context. So it's not that multilateralism and regionalism, when it comes to international trade, haven't coexisted. They have coexisted for a very long time. In fact, if you look at the data at the WTO, it will tell you that as soon as the WTO came into existence in 1995, you also witnessed a proliferation of regional trade agreements. In fact, NAFTA, which was negotiated in 1992, the North American Free Trade Area Agreement, which Donald Trump killed in his first presidency, NAFTA actually played a critical role in giving a fillip to the Uruguay round of negotiations that led to the creation of the WTO. So multilateralism, regionalism have coexisted. So if India is trying to sign regional trade agreements or free trade agreements, that on its own does not necessarily mean that India is distancing itself from multilateralism. That's point number one. Point number two, I think even on free trade agreements, India's stand hasn't been consistent. And this is something that we need to understand. If we go back in time, India was little late to sign FTAs, unlike East Asian economies. It started signing in late 1990s, but it picked up pace in the 2000s. So India signed FTAs with several leading Asian economies such as Singapore, Malaysia, Korea, Japan. It started negotiating for RCEP, the Regional Comprehensive Economic Partnership Agreement. 6, 7 years was spent in negotiating that agreement, and then one fine day, India decided we'll famously walk out of RCEP negotiations, and rest of the 15 countries went ahead. So at that point of time, from 2014 till about 2013, 2014 till about 2020, there was a lot of rhetoric against FTA emanating from the government. There was this Niti Aayog paper which had said that signing FTAs is harmful, and then later that paper was retracted. So then again, from 2021, 2020, when the pandemic hit us and we realized our vulnerabilities, that we are not part of global supply chains, etc., it was then when we again started to show interest in signing FTAs. And the FTAs that we are witnessing now, the negotiations are a product of that thinking that came up in 2020-21. So this is the larger approach that India has, and it has not been very consistent. Now, on the FTAs as well, I mean, uh, signing an FTA with the UK might make good headline, but UK is not really a very big economy, and so I'm not very sure to what extent will it help Indian goods and Indian services. Signing with the EU might be useful because EU is a bigger market, but then there would be demands on India as well, and what India will have to give in return. But I think where India is missing is India is not able to capitalize on the ASEAN market despite having an FTA with ASEAN. And I think that has got to do more with trade rules. That has got to do more with your own internal economic structure and the lack of economic reforms internally, because of which you're not able to benefit from the FTAs that you have signed.
Could you expand a little bit on that? Because I'm going to come to China after this, but the ASEAN seems like a good stepping stone before we discuss China. That what is it that is stopping India from going into it more fully with the ASEAN?
So India signed an FTA with ASEAN. India also has an investment treaty with ASEAN.
Correct.
But what has happened is that given the competitiveness of ASEAN, ASEAN has been able to export much more to India than what India has been able to export to ASEAN. Now, that again, more than trade function, that is actually a function of our weak manufacturing capability. Until you strengthen your manufacturing capability, till you make it, make it make it easy to produce goods in India, you will not be able to benefit from these trade agreements, because trade agreements provide you an opportunity, but that rests on the assumption that you are ready to take on those opportunities, which unfortunately hasn't happened because of internal economic structures and reasons.
No, absolutely. And I think the this brings us beautifully to the dragon in the room, which is China. Uh, and the fact is that even during uh, Pahalgam and most discussions that we have around the Indo-Pak issue, I mean, there is always the lurking presence of China, sometimes mentioned, sometimes not mentioned, but particularly in the context of trade, since the world order is changing with Trump's presidency, and China is undoubtedly an important pole in this global world order, irrespective of how it shapes up. How do you see India and China, particularly as an international lawyer, given the differences in legal culture that exists in both the countries, uh, the differences in language? How do you see India and China as an international lawyer?
I would say that China has invested massively in building its international law capacity in the last 2, 3 decades, which India hasn't been able to do. A lot of it, well, all of it is not because of lack of financial resources. A good part of it is because of lack of strategic vision. So China has been able to, I mean, for example, if you look at the literature on international trade law or any branch of international law in the 80s and 90s, you will struggle to find
Very few Chinese scholars.
Chinese lawyers
Yeah,
writing papers in
exactly.
these in top journals. Today, if you pick up any issue of any leading trade journal or any international law journal, you will find some such Chinese scholar publishing there, which hasn't happened with India. So it demonstrates that China has been able to invest massively in building its capacity. China has built massively in building its economic capacity, because of which it is now able to benefit from these trade agreements. If you look at the reason why India walked out of RCEP, if you look at the work of ASEAN scholars, they will tell you that RCEP is actually the ASEAN plus six formula. It's ASEAN way of integrating
Right.
with the larger world. But then many other scholars say that no, it's not ASEAN plus six, it's China plus 14 or 15, right? It's
Yeah.
basically a Chinese led FTA. And India signing it would basically mean you're signing an FTA with China, which would be a death knell for all your industries and all your manufacturing. So from that standpoint, it's good that India walked out of RCEP. But then the other viewpoint of some other economists is that you will have to confront competition, and you can't run away from competition for a very long time. So from that standpoint, you will have to be, you will have to compete with Chinese products. Even without an RCEP, you have Chinese goods flooding Indian markets. And you're not able to compete with it. So you will have to find, solutions to those problems. But on the larger point, I think China is investing massively in building international law, in shaping international law norms, what it is doing in the South China Sea, and how it is. It has one of the biggest delegations at the WTO, which doesn't often speak, but it is very much present there. Chinese Journal of International Law, which started just 2 decades back, is today one of the leading journals in international law, and see where the Indian Journal of International Law is, despite being 60 years old. So this actually demonstrates uh, that China has got the better strategic vision than what we have, and we have a lot of catch up to do on this.
So, so, so then let me ask you, and you had earlier spoken about one of the ways in which thinking about doing this catch up is by building a cadre of international lawyers in India, hiring younger people who can come into the legal and treaties division. or perhaps even more radically, thinking about international lawyers in every government ministry which has an international law function. Because, as you said, willy nilly, that's what tends to happen. That a lot of the trade negotiations are led by the Ministry of Commerce. And then on an ad hoc basis, they were wise to appoint you. But on an ad hoc basis, these appointments are made. And so there is no system, there is no structured way in which there is international law expertise as part of the state apparatus in India. So, if you were asked this question, then how would you build that international law expertise within the within state capacity in India? What are the three top things that you would do?
So I think it has to start with first boosting our legal education and our universities, because that is the place, that is the nursery from where all these lawyers come up. And
Prabhash, I'll
you
stop you for 1 minute
okay,
there.
yeah,
Uh,
yeah, yeah.
and I'm saying this from my experience also when I was in third and fourth year in law school, and I see a lot of interns who come to Vidhi. International law is still a very sexy subject in law school. A lot of people want to do it, they want to study it. It almost seems like, in some sense, to an untrained legal mind, as the pinnacle of legal education, or at least that's what used to be the case, at least till 5 years before. The fact is that once somebody is in that job market, okay, and trying to see that what can I actually do with this, that's where the real problem with international law comes. As in, it's taught very well. I feel like the course curriculum is very good, but that doesn't translate into anything, which is where this problem begins.
No, Orgo, I'll slightly differ on that point. So my point is not about the quality of students. Yes, the students are doing very well. I mean, whether they are taught that well or not, one can have a debate. But the students are doing very well. I mean, that is evident from the number of moot court competitions, be it Jessup or be it the FDI moot or be it the John Jackson moot, etc. Even the space law moot. So students are doing very well. That's absolutely fine. But my point is slightly different. My point is whether the law schools are producing the kind of academic research that is expected, or that needs to come out from a country like India, which wants to make its presence felt in the world. And I think that is where we are missing. That is
Absolutely.
where we
And
are
that's
lacking
just not an
behind.
international law problem. That's a problem with
That's
legal
yeah.
research in
Yes,
general
yes,
in
I
Indian
agree. I
academia.
agree. It's a general legal research problem, but since we're talking about international law, I want to
Sure.
flag international law
Agreed.
that if there are 1,700 law schools in the country, but if you were to ask, let me write down the name of 10, 15, 20 top international lawyers who have published cutting edge research in different areas of international law, you will struggle. We will struggle to do that. So strengthening law schools and universities has to be a very important thing. The second thing, but that's a long term vision that can't be done overnight. But within the government, I'll give you examples where the government has actually taken certain steps. For example, the Commerce Ministry has set up two think tanks, the Center for Trade and Investment Law and the Center for WTO Studies, which work under the aegis of the Indian Institute of Foreign Trade. Now,
Okay.
these two think tanks have many young LLM, LLB graduates who are interested in trade law and investment law. They are helping, giving negotiating inputs to the Commerce Ministry on trade and investment matters, including to the Finance Ministry. But the problem that I see is that these are not actually think tanks. They have become, if I may say, the back end office, that all legal work gets delegated there and then they do it, which then defeats the purpose of them being sounding boards for strong research and stuff like that. So I think there are two things that the government can do. One is to have more and more international lawyers within the government system, and second is to create more independent think tanks and give them the independence that even if you want to criticize a stand that India has taken, you should be free to do that. I mean, just because you're funded by the government does not mean that you can't criticize, you can't question a policy or stuff like that. So these are the two things that the government will have to do. Now, if you look at the legal and treaties division or even the MEA, there's this new trend of hiring consultants, young LLMs or fresh LLMs being hired as consultants, which is very good for these individuals. It gives them great exposure. But I'm not very sure to what extent will these young consultants be able to contribute, since it's an ad hoc position. They are hired on a contractual basis, which moves from 1 year to another year. There's no stability in terms of tenure, etc. So these guys then move on to other things as and when they get the opportunity. Now, I'm not very sure. It's very good for these individuals, but I'm not very sure how it helps in strengthening the state capacity. So I think what needs to be done is to revamp the legal and treaties division. There was a report of a parliamentary committee way back in 2016, which had actually suggested creation of what is known as the Department of International Law Affairs within the Law Ministry. And you take this legal and treaties division out of MEA, you have a full-fledged department within the Law Ministry, and then let that department take care of all international law matters. Now, one can discuss whether that's a good proposal or a bad proposal, but this was made way back in 2016. But having more international law people within the system on a tenured basis is going to help. And third, and most importantly, I think the government needs to have a system of institutionalized consultation with academics, with outside experts who are working in this area. I have been lucky that I got a few opportunities to advise the government, although whether the process was robust or not, we can have a debate on that. But at least I got the opportunity to do that. But again, it was very ad hoc. It was based on the initiative of, say, one joint secretary who has a strategic vision, but that overall vision is still missing. So it doesn't quite help. What needs to be done is a very institutionalized mechanism of consulting academics. So let's assume we are negotiating a law of the sea treaty. Let's identify 5 or 6 people in India who have done extensive work in this area. They may be in Cochin, they may be in some NLU in Assam or anywhere, and let's identify and then form a committee and have a regular basis through which we interact with them and take their inputs, even if they are critical of the government. Because if you don't do that, then you are missing out on a very important, strategic element. So these are the three things which I think should be done in order to build state capacity.
No, I think there's a lot of ideas there to unpack, and I think if I were to summarize them, it's essentially that the state should start getting serious about international law and international lawyers, and see the fact that we are not utilizing our potential as a lost opportunity. I
Hmm.
think the beginnings of that are there, but with every incident like Pahalgam, I think it comes back to us in terms of how much more we can do in terms of international law, and how much more we need to do given the fact that the world is going the way it is going and we don't want to be left behind.
Yes.
So, Prabhash, I think we could go on for a very long time, but I have to stop it here. I think it's been a wonderful conversation, ranging from the macro to the very micro. And I hope that there's something in it for everyone. So thank you very much for joining me on this episode, Prabhash. It was a real pleasure talking to you.